28/1993.
In this, there is applicant number 2 had died, and substitution petition has been filed. Petition is within time. The legal heirs, they have already filed wakalat. IE number is 1104.
Any objection? Yes, respondent?
Yes.
Any objection? IE number 11042 of 2025. Counsel for the parties are present. It has been submitted that this interlocutory application has been filed for substitution of this appellant number
2.
Appellant number 2 within bracket BB Sayyada Begum, who died on 8/8/2025. The name of legal heirs and successors have been mentioned in paragraph 5 of the interlocutory application. The counsel for the appellant has submitted that the wakalatnama on behalf of the legal heirs and successors have already been placed on record along with the interlocutory application. The learned counsel for the respondents has no serious objection so far as substitution is concerned. Considering the future facts and circumstances, IE number 11042 of 25 is hereby allowed. Counsel for the appellant is directed to delete the name of the appellant number 2 from the cost title and insert the name of legal heirs and successors as mentioned in the interlocutory application. इसमें कुछ हाथ से corrections हैं, mismatch रहेगा तो दिक्कत होगा.
अच्छा, ठीक.
तो you see this
हाँ.
and then you do the
ठीक.
सैयदा का spelling में error.
हाँ.
तो थोड़ा देख कर करना. आइए देख के करिए.
हाँ, ठीक.
कभी-कभी corresponding आपकी कॉपी में correction नहीं भी होगा. कर लीजिए. अब कब रखना है? बताइए.
और सेकंड नंबर एक है.
एक और है.
एक सेकंड जो दूसरा अपील है उसमें भी सेम पार्टी है.
कहाँ है दूसरा?
वो
उसमें आइए हो चुका है. आइए अलाउ हो चुका है उसमें.
नहीं, उसमें भी डेथ सेम पार्टी है.
आइए नंबर
बट यस.
Item 2.
रिस्पोंडेंट नंबर बताइए. अपीलाइन नंबर बताइए.
इसमें है 11040. This is second appeal number 131 of 1998.
अपीलाइन नंबर 1C has expired.
नहीं, इसमें 1C is filing.
अच्छा 1C is
respondent number 2 has
same story.
respondent number.
अच्छा इसमें respondent number 2 has expired. Are you getting it? In this 11040 of 25, essay number 131 of 1998 within bracket Patna. Respondent number 2 has expired.
Same.
And same wakalatnama is there.
I am referring on behalf of the
respondent. Legal heirs of.
legal heirs of the
Wakalatnama
respondent.
कहाँ
I am ready to file. Will take me.
लिखिए इसको लिखिए. IE number 11040 of 2025 in essay number 131 of 1998 within bracket P. Counsel for the appellant has submitted that respondent number 2 BB Sayyada Begum died on 8/8/2025. And the name of legal heirs and successors have been mentioned in paragraph 5 of the interlocutory application. He submits that in the connected appeal, she is appellant number 2 and has already been substituted by the respondent. Learned counsel for the respondents has no appellants. इसमें आप appellant?
नहीं, इसमें भी respondent 1.
तो appellant कौन है?
1 है, इसमें हम आए.
अच्छा. Learned counsel for the respondent has no serious objection so far as prayer for substitution is concerned. Mr. नाम बताइए अपना.
Vijay Shankar Jha
submits that he has already received wakalatnama on behalf of the proposed legal heirs and successors, which he undertakes to file during the proceedings.
today.
After hearing the counsel for the parties and considering the facts and circumstances of this case, IE number 11040 of 2025 is hereby allowed. The counsel for the appellant is directed to delete the name of the respondent number 2 from the cause title and insert the name of her legal heirs and successors in red ink during the proceeding. The Mr. Vijay Shankar Jha to file wakalatnama during the proceeding. अब बताइए आगे. 95 का 98 का मैटर है.
I'll pray that
93 का मैटर है.
no. Your Lordship may only be started after vacation, Your Lordship.
What is the substantial question of law?
Pardon?
substantial question.
अच्छा
After section 145, it becomes barred. What happens? I'm not able to understand.
Actually what had happened that the appellant, the ancestor of the appellant and the contesting respondent, there was already a proceeding under section 145 in the year 1962. Only year I made.
Then no problem. I
So
must know the
after,
conclusion.
yes, in 62 there was already a proceeding with related to the suit property itself between the appellant hearing and the contesting respondent. Now that in that proceeding I was held to be in possession of the property and their claim of possession was rejected. Now after in the year 1976 the contesting respondent and a third party, they both filed a partition suit and without impleading the person who was found to be in possession, that means I was never impleaded, and they got that suit was ultimately compromised.
Inter-party.
Yes, inter-party it was compromised and that was sought to be executed against me. I was in the execution case, I was found to be in possession and therefore I filed a suit raising that the said suit was absolutely
Gained
collusive.
title on the basis of adverse possession.
I although I was claiming on the basis of succession, but my alternative claim would be because I was held to be in possession in a proceeding under section 145, then I was a necessary party.
Why a substantial question of law that the suit filed by the defendant for declaration of title is maintainable after lapse of 12 years? Why this 12 years is coming?
Yes.
After
Because
lapse of 12 years?
yes.
Of the declaration of
I'll
possession.
explain. Because the defendant in the instant suit, he was the plaintiff in the earlier suit where he files a suit in the year 1976 and that was after 12 years from the date when my possession was declared. He files a suit.
Once a possession is declared, it's in perpetuity. Unless one person is dispossessed.
Yes, exactly.
Why this 12 years will come in?
12 years is because, Your Lordship, they were required to have instituted a suit against me within a period of 12 years because.
Seeking recovery.
Yes, seeking recovery. This is very important. Seeking recovery of possession, a suit was required to be filed and that too within a period of 12. So therefore, the suit which was filed in 1976, that by itself was barred by limitation, but even otherwise I was not made a party. And that could not have been enforced. Therefore, I filed a suit.
There is a Muslim law involved in this case?
Succession also, because I am also claiming on the basis of succession.
Succession from Jumlati Khanam.
From the common ancestor. We say that the property belonged to, and it was our ancestor property, and the property had also devolved on me, and this was a claim in the 145 proceeding also.
That's right. When you want to do?
After
करना है सर ये बताइए.
the opening के बाद जल्दी.
जिस सर से पूछ लो. हाँ बताइए सर कब करना है?
खुलने के बाद 2-3 दिन के बाद खुलने के 2-3 दिन के बाद बुध बृहस्पति
Counsel for the parties have submitted that there is no impediment in final hearing of these matters. Correct? सब चीज complete है, substitution
हाँ
complete है, party
बिल्कुल
was
सब सोचने के लिए रुका हुआ था
Substitution नहीं हुई.
right.
सब्स्टिट्यूशन हो गया
Notes बनाएंगे आप लोग?
बनाए हैं लेकिन
वो सबमिटेड भी है बल्कि सबमिटेड भी होगा रियल फाइल में देखने से हम लोग देख लेते हैं वो बना हुआ था उसी समय हम लोग जो वो कोड नंबर का 20 में बहस की थी वहीं पर वो बोले थे कि
लेकिन एक बार फाइनली दे
हम लोग दे देंगे
फ्रेश दे.
कोई क्लमजी फैक्ट्स है नहीं फैक्ट बहुत क्लियर है सब करने पर निशान आपके पास से तो हम लोग को दिक्कत नहीं
किसी कोर्ट में कोई दिक्कत नहीं है, बस आप लोग तैयार होइए.
नहीं ठीक है, दोनों तैयार है, सर भी तैयार है.
देखिए हमें नहीं पता छुट्टी के बाद कौन सा
हाँ क्या होगा लेकिन डेट एक रख दिया गया हम लोग
डेट हमें
we are much over.
for every case there has to be
जी,
a
जी.
date, so there will be.
अरे बहुत दिन से केस लटक रहा है वो आपके पास बोलने से हम क्या कब इसका मुहूर्त पूरा होगा।
Instead, therefore, I say that your lordship may start because your lordship has partly heard. Your lordship may hear in part and then post it.
इस तरह से नहीं कर सकते हैं, it is not
चलिए।
proper also.
ठीक है।
पाँच हट को होकर के चला आया यहाँ पर।
नहीं, ठीक है।
ठीक है, ठीक करेंगे। With the consent of the learned counsel for the parties, post this case for final disposal on 8th of October,
जी
8 अक्टूबर,
जी कोई दिक्कत नहीं।
ठीक है?
हाँ
Okay, parties to submit short synopsis, list of dates and the judgments which they seek to rely upon.
ठीक है।
Photocopy के साथ दे
कोर्ट का आदेश
देंगे।
जो भी होगा।
Latest by 6 तारीख तक दे देंगे।
Yes.
पढ़ना पड़ता है सर हमको,
हाँ ठीक है।
थोड़ा आप लोग की तरह स्पीड से नहीं चलते हैं।
तो जब एक जजमेंट होता है तो पूरा एग्जॉस्शन होता है उसमें। चलिए अगला।
फाइनल कोई टाइम फिक्स करें?
नहीं टाइम
ठीक।
तो अब
वैसे ये
क्या होता है
फर्स्ट केस रहेगा।
अरे मतलब तो क्या कुछ रहेगा।
ये अभी पता नहीं।
केस में हम लोग देखिए ये लोग जवान लड़का है हम लोग का।
नहीं
हम भी कभी इनके उम्र में थे तो दौड़ लेते थे 4 जगह, दो जगह बहस करते जाना नहीं।
ठीक है।
On the daily list, targeted cases, the heading for orders item.
आपके पास ऑर्डिनरी केस थोड़ी आता है सर। आपके पास ऑर्डिनरी केस थोड़ी आता है, तो इसमें 2-4 केस बहुत हैं।
हम लोग का संथाल पर लोग का क्लाइंट गरीब कोई बात इसको जब एक ऑर्डर है
इसमें आप अपने नाम
का एवेटमेंट मैटर जो है
see the order details are to
इसमें जैसा ये कल एक जवाब दिया वो कहाँ से वो क्लाइंट को बुलाएंगे। इसमें एक चीज देख लिया जाए, 1/5/2003 का आदेश देख लिया जाए। एबेटमेंट तो इनका हो ही गया है, लेकिन ये सारा मैटर एबेटमेंट वाला जो है 1/5 का आदेश रिलेट द क्वेश्चन ऑफ कंपिटेंसी ऑफ अपील ऑन अकाउंट ऑफ इट्स एबेटमेंट एज अगेंस्ट ये ऑर्डर डेटेड 1/5/2003 का
2003।
जी उसी में इसका है। इसके सारा एबेटमेंट एक ही साथ हियरिंग में कंसीडर हो। इसमें भी क्या बात है, कल जवाब दिए हैं तो उसका जवाब का जवाब क्लाइंट कहाँ से आएगा। 1/5/2003
98 के बाद तो 1999 1/5/2003
तीन जी
98 के बाद मेरे पास ऑर्डर शीट जो है वो सीधे 99 का ऑर्डर नंबर 4 ऑर्डर नंबर
को ठीक है
2003 का ऑर्डर है।
जी
1/5/2003
कोड भी किया
अच्छा,
हमने
हाँ,
डेडलाइन
अच्छा।
को
ठीक है 2003।
जी इसमें दिया है क्वेश्चन ऑफ कंपिटेंसी ऑफ द अपील ऑन अकाउंट ऑफ इट्स एबेटमेंट एज अगेंस्ट एयर्स ऑफ रिसीप्ट ऑफ। तो अब इसमें एबेटमेंट अभी फिर लगा है सारा
वो
एबेटमेंट।
सारा अबेटमेंट एक ही साथ डिसाइड
जी
होगा।
जी 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 वही मेरा था।
किसके अगेंस्ट में अबेट हो गया बताइए। पहले अबेटमेंट सुनेंगे उसके बाद मेरिट सुनेंगे जब इसका फाइनल
उसी में जी एक ही
पहले अबेट में अगर अबेट हो गया तो फिर मेरिट में क्या डिसाइड
मेरिट का क्या बात है तो उसको देख लिया जाएगा।
बताइए कौन किसके अगेंस्ट में अबेट हुआ।
रेस्पोंडेंट नंबर 1 से था,
रेस्पोंडेंट नंबर
1 से था और अभी जो है फिर नया जो है सब
थोड़ा पास नहीं हुआ
सबके लिए है सारा
एक ही
चीज
है।
उसी में कंसीडर हो।
एक ही रेस्पोंडेंट नंबर 1 के तरफ से
अभी
रिस्पोंडेंट नंबर 1 के ही तरफ से जो फर्दर लीगल ईयर्स होंगे उनके अगेंस्ट में क्या अबेट किया है।
और रेस्पोंडेंट नंबर 5 जो है अभी
ये रेस्पोंडेंट नंबर 4 अबेट कर गया है।
जी और 5
इसमें पिटीशन
और
फाइल
अभी-
की है
रेस्पोंडेंट नंबर 5 अबेट कर गया है।
जो भी हो
नहीं 5 का तो सब्स्टिट्यूशन वगैरह फाइल हुआ है सर उसको जब तक हम उसको सब्स्टिट्यूशन तो देखना पड़ेगा।
एबेटमेंट जो है ऑटोमेटिक प्रोसीड्यूर है वो समय 90 दिन 60 दिन के बाद वो ऑटोमेटिक
सर
होता है।
रेस्पोंडेंट नंबर जो भी है
जो भी आदेश पारित किया जाएगा हमको
नहीं ये नहीं बोल रहे। रेस्पोंडेंट नंबर 5 का डेथ हुआ है
जी
हैज एक्सपायर्ड प्रो फॉर्मा रेस्पोंडेंट तो उनका सब्स्टिट्यूशन फाइल हुआ है। तो रेस्पोंडेंट नंबर 5 के लीगल ईयर्स को तो भेजना पड़ेगा ना नोटिस, बिना उसके कैसे होगा। नोटिस गया है क्या उनको?
नहीं
ऐसे तो नहीं हो सकता है।
Substitute भी नहीं किया।
नहीं, उनको सुन के ही करेंगे। उनको सुन के एक बार को जैसे अबेटमेंट हम लोग देखेंगे। So there are two situations. One is the proceeding is abated and there is no substitution. Second is proceeding is abated but there is a petition for substitution
Application for
setting
substitution.
aside. So that has to be considered.
नहीं तो अभी
तब
तो
तक उसको disposal
उसी
नहीं
के लिए
करेंगे।
तो समय उमेर मिला था और उसमें दिए हम काउंटर किए हैं। इसमें एक निशिकांत मुर्मू मर गए थे जो कि सब्स्टिट्यूटेड एयर थे इन प्लेस ऑफ बाबूलाल मुर्मू, उसका डेथ हो गया। वो
रेस्पोंडेंट नंबर बताएंगे ना सर।
ये रेस्पोंडेंट नंबर 4
रेस्पोंडेंट नंबर
रेस्पोंडेंट नंबर 1 बाबूलाल
वो
मुर्मू
तो हो
के
गया, उसका तो सब्स्टिट्यूशन हुआ नहीं, बात खत्म हो गया।
नहीं नहीं बाबूलाल मुर्मू का जो एयर का सब्स्टिट्यूशन हुआ था ना वो एयर भी मर गया।
सर एक सेकंड, एक एक रेस्पोंडेंट करके पकड़ो। रेस्पोंडेंट नंबर 1 का कोई सब्स्टिट्यूशन पिटीशन फाइल हुआ
फाइल
था?
हुआ था जो हुआ तो उसी के लिए अभी जो आदेश एबेटमेंट के लिए जो पड़ा हुआ है 25/2/2003 का आदेश देखा जाए।
सर रेस्पोंडेंट नंबर 1 के सब्स्टिट्यूशन का कौन सा है? आइए
रेस्पोंडेंट नंबर 1 का जो सब्स्टिट्यूशन का है ये ऑर्डर डेटेड 1 देखा गया
सर,
ना?
ऑर्डर डेटेड हम देख लिए।
जी तो
सर
उसमें
एक सेकंड, whenever a proceeding has abated, right? Somebody has expired, there is no petition for substitution, proceeding abates, right? It can be possible that at a later stage there is a petition for setting aside abatement and substitution. Was any substitution ever filed with respect to respondent number 1? रेस्पोंडेंट नंबर 1 का तो कुछ लिखा नहीं है।
वही उसी का है। उसमें यदि हुआ था सब्स्टिट्यूशन रेस्पोंडेंट नंबर 1 का
नहीं हुआ।
नहीं हुआ
रेस्पोंडेंट नंबर
तब
2 का हुआ था सब्स्टिट्यूशन। तो रेस्पोंडेंट नंबर 1 का कोई सब्स्टिट्यूशन
Substitution
पिटीशन
हुआ
ना
ही
फाइल
नहीं।
हुआ ना पेंडिंग है।
जी
ठीक है। तो रेस्पोंडेंट नंबर 1 का स्टोरी इज ओवर।
इनका कहना है रेस्पोंडेंट नंबर 2 का सभी मर गए हैं। एक 2A 2A be substituted here of the respondent number 2 died like per the order
Respondent number 2 has been substituted, 2A and 2B. 2B expired and he has been deleted. 2C नहीं है।
2B को अभी एफिडेविट किए हैं। 2B अभी एफिडेविट किए हैं अभी जस्ट।
वो भी तो हुआ आपको पक्का
2B has been deleted by order dated 8/3/2013.
We deleted but he had the
इसमें लिखा हुआ है?
2A करके लिखा हुआ है, इसलिए कंफ्यूजन क्रिएट
अच्छा, इमली हेम्ब्रम।
जी, क्योंकि नाम इमली हेम्ब्रम का तो 2 डिलीट कर दिया गया, तो 2B रहेगा 2B के नाम से।
तो अभी एफिडेविट किसने फाइल किया? इमली हेम्ब्रम।
इनकी तरफ से फाइल हुआ है डिटेल जो
इमली who is अरे भाई आप लोग समझते नहीं, फाइल भी नहीं पता होता।
जी जी
रिकॉर्ड में 2A 2B दिख रहा है। 2B इमली देवी इमली हेम्ब्रम हैज बीन डिलीटेड। 2C तो कुछ है ही नहीं यहाँ पर।
इमली नेम है डिलीटेड है
वो हैंड एक्चुअली
इमली का
वो प्रिंट हो गया था, इस तरह का कोई भी कंटिन्यू नहीं है, इसलिए उसे
हमको खुद रिकॉर्ड हम खुद एग्जामिन करेंगे।
सर अभी एग्जामिन हम लोग कर ही रहे हैं। आप लोग को इतना दिन से टाइम नहीं मिला, हम लोग थोड़ा टाइम निकाल के एग्जामिन कर रहे हैं।
इमली देवी का नाम डिलीट हो गया, मर गया 8/3/2013 के ऑर्डर से। 8/3/2013 को ऑर्डर किया।
2B to 2F लिखा हुआ है।
वैसा कुछ नहीं,
तो कितने इनके सब्स्टिट्यूटेड हियर हैं?
सिर्फ 2 है।
2A and 2B। ठीक है, तो ये ऑर्डर में एरर है। 8/3/2013 2B to 2F है, जबकि होना चाहिए था 2A to 2B। ठीक है, उसके बाद इमली हेम्ब्रम हैज बीन डिलीटेड
बाय ऑर्डर डेटेड 8/3/2013।
इमली हेम्ब्रम हैज बीन डिलीटेड। On account of death,
Yes, ma'am.
Okay.
By order dated 8/3/2023.
तो 2 का बचा only 2A,
Yes, ma'am.
right? What else about respondent number 2?
Respondent number 2.
बस हो गया, इतना ही तो है.
हाँ, लिख के दे रहे हैं कि मर गया है, मर चुका है, डिटेल दिए नहीं हैं।
कौन नहीं मर, कौन मर गया? 2A has expired.
हाँ, expired. But to be आका है,
2B,
I think
नाम बताइए who has expired.
ओम प्रकाश
ओम प्रकाश तो जिंदा है, प्रकाश निशिकांत के बारे में
नहीं, ऑर्डर शीट में तो आया हुआ है।
ओम प्रकाश
प्रीवियस ऑर्डर में काइंडली
Just a moment, we will see that. Om Prakash is alive.
एलाई इधर स्वान भी
देखा जाए ऑर्डर डेटेड 8/9/2025 पर नंबर 5.
Respondents have also submitted their details of details
You see,
legal affairs of
Sir, just a moment. Sir, respondent number 2, वो आप ऑर्डर छोड़ दीजिए, हम लोग को पूरा रेक्टिफाई करना है. Respondent number 2 had 2 legal years, 2A and 2B. Imli Devi has expired, correct? Yes. So she has already been deleted. According to you, Om Prakash is alive.
ओम प्रकाश से
तो कहानी खत्म,
जी
right?
जी
पहले इसको ठीक कर. The learned counsel for the parties are present. It has been pointed out that so far as respondent number 1 is concerned, reference may be had to order dated 25/2/2003, and it has been observed therein, 6/1/2005. Sorry, reference may be had to order dated 25/2/2003 and order dated 1/5/2003. It is not in dispute that respondent number 1 has expired long back and the proceeding has abated, and it has been observed that the incompetence of the appeal on account of abatement in connection with respondent number 1 will be considered at the time of final hearing. Counsel for the parties have jointly submitted that no petition for substitution of respondent number 1 has been thereafter filed. Right. So far as respondent number 2 is concerned, the learned counsel for the parties have submitted that, and as per interlocutory, 3 daughters भी थी भाई,
नहीं डॉक्टर
दिखाई दे जरा, आइए नंबर दीजिए, आइए नंबर 3743. आप कंटिन्यू करिए. It has been submitted that the order regarding substitution is dated 8/3/2013. The councils have submitted that there were only 2 legal years to be substituted. That is Om Prakash Murmu and Imali Murmu.
ईमेलिंग कर दिया
Imli Murmu. But in the said order, it has been wrongly mentioned that there were the proposed legal years were respondent number 2B to 2F. It has been also submitted that Imli Hembram has already expired.
ईमेली ना
Imali
ईमेली
had already expired. Murmu Hembram क्या है? Hembram has already expired, and she has been deleted by the order dated 8/3/2013. दिखाई जा रहा है इसमें कितना लीगल है?
2030.
2013
कैसे आप बोलते हैं? Respondent number 2 पे और भी लीगल ईयर्स थे?
अभी तो क्या सब इंदिली है, ओम प्रकाश है, उसका एक भाई
इमली का
है।
नाम डिलीट हो गया, 8/3/2023।
अरे इमली का नाम तो डिलीट हो गया, जो आप बोल रहे हैं कि उसके 2 ही लीगल ईयर्स थे, दैट इज नॉट करेक्ट।
तीन
3 नहीं 5,
हाँ, तो जो भी होगा वो दे हैव बीन सर,
ये एकदम सही है।
वो बिल्कुल सही।
कुछ भी बोलते हैं। देखिए जरा आइए नंबर, और इमली हेम्ब्रम के भी बहुत सारे लीगल ईयर्स हैं। प्रवीण, सरिता, सुमित्रा, सुरेखा।
उसी में टूके ही कर रहे हैं।
हाँ, बस भगवान ही बचा सकता है हमको। आधा घंटा से बस यही चक चक कर, कोई रिस्पॉन्सिबिलिटी नहीं है सबमिशन करने से। ऑर्डर गलत है, ऐसे हम लोग चेक ना करें तो आपके बात पे कुछ भी लिखे।
थ्री डॉट
एग्जाम कर लिए।
ये रिस्पॉन्डेंट नंबर 2 के बारे में फिर से the perusal of the records reveal that by the order dated 8/3/2013, IA number 3743 of 2012 was disposed of it was the IA number 3743 of 2012 revealed that following statements were made in the interlocutory application. Paragraph 3 and 4 इसका आइए का कोट करेंगे, ठीक है? From the cause title where the necessary amendments have been made, it appears that the appellant has inserted only Imali, Hembram and Om Prakash Murmu and has completely left out 2C to 2F. Counsel for the appellant is permitted to carry out further correction in the constant. अब इन लोगों को नोटिस जाएगा, क्योंकि इन लोगों को अभी तक नोटिस नहीं गया है। बताइए। Let notice be issued to the aforesaid respondents, aforesaid legal years of respondent number 2, that is 2C to 2F. For which requisites we serve to concerned police station, for which requisites we filed by Friday, and also speed post, okay? Office to track speed post delivery. दिखाइए। है ना, नाम है ना सबका, तो कैसे बोल दी? How did you make that statement? ये तो हो गया 2 का काम है, 4 और 5 का काम इसमें, स्टोरी ऑफ 4 and 5. 4 नंबर he has expired.
यस सर, कल फाइल भी किए थे इसका।
आइए कौन सा?
4 का फाइल।
What is it that has been filed?
402.
403 है 402. आइए नंबर 13402 क्या किसके लिए? रिस्पॉन्ड नंबर 4. इसमें क्या बोलना है सर आपको?
तो अबेटमेंट रहेगा ही ना, वो इसलिए वो सारा उसमें कंसीडर होगा।
नहीं सर, इसमें सब्स्टिट्यूशन फाइल हो चुका है, सेटिंग असाइड अबेटमेंट भी फाइल हुआ।
तो वो भी कितना दिन के बाद।
तो आप इसको अपोज करिए,
पहले अबेटमेंट
आप इसको अपोज करिए।
हाँ हम तो काउंटर दिए हुए हैं, वो तो करेंगे। इट हैज अबेटेड ऑलरेडी
That's
एज
it.
अगेंस्ट देयर केयर्स।
क्या रीजन है आपका इतना दिन बाद आप आए?
कोई सेटिस्फैक्टरी नहीं है।
तो आए हैं, मैंने तो जानते नहीं थे
कहाँ
माइनर थे
लिखे?
इसमें।
कहाँ लिखे हैं?
कोई एक्सप्लेनेशन नहीं
31 वर्ष इनका मर्जी होता था
बताइए क्या लिखे हैं?
जिसमें सूट कर
Did pro forma respondent file any written statement? Did he file any written statement? They say, sir, they say that he died in 2001, and thereafter, when the notice was issued to them, they came to know. यहाँ से notice गया था.
कुछ लिखा ही नहीं हुआ है इसमें एक्सप्लेनेशन का।
That appellant have come to know after substitution of the name that pro forma respondent number 4 is the party in the case.
तो अपील के मेमो में ही नाम है तो कैसे ऐसा नहीं हो सकता है ना?
उसमें
ऐसा कैसे होगा एक्सप्लेनेशन? ऑलरेडी उसमें रेस्पोंडेंट हैं, ऑल थ्रू प्लेंटिफ यही थे,
तभी हम सब्स्टिट्यूटेड
इसलिए उन्होंने हमारा सिंपल सबमिशन है। अभी इसमें डीप में जाने के लिए नहीं कहते हैं, इसको एक ही बार जो हियरिंग में रखा जाएगा ना, इनको जो करना है करना है, उसके बाद इस अबेटमेंट मैटर को सारा एक साथ कर देंगे। दैट वुड बी माय सबमिशन ऑल द अबेटमेंट मैटर। आज उसके बारे में कोई आदेश नहीं दिया है, सिंपल
लिखिए आई नंबर 13402 and 13403 has been filed in connection with deceased respondent number 4, who is said to have expired on 20/2/2001. The learned counsel for the respondent has submitted that there is enormous delay in filing the petition for substitution. इन लोगों का वकालतनामा कहाँ है? रेस्पोंडेंट का वकालतनामा आपके पास है? रेस्पोंडेंट को बिना सुने उसका अबेटमेंट कैसे डिसाइड करना है?
तो नोटिस तो करने का इनको या करेक्शन करेंगे, जो एयर्स वगैरह जितना है सब कुछ में ऐड करेंगे, तो प्रक्रिया भी इनको फॉलो करना पड़ेगा और उसके पर नोटिस जाएगा, ई जोड़ लेंगे, उसके बाद नोटिस जाएगा उनके एड्रेस पर।
Let notice be issued to the
पहले वो काम हो जाए।
let notice be issued to the proposed legal heirs and successors
जी
of respondent number 4, whose details has been mentioned in paragraph 7 of the interlocutory application through the concerned police station for which requisites be filed by Friday. In both the interlocutory application, दोनों में आप नोटिस करेंगे उनको, ठीक है? वो लोग जब रिकॉर्ड पे आएंगे तब हम लोग सोचेंगे कैसे करें। और कोई आइए पेंडिंग है? रिस्पॉन्ड नंबर 5, रिस्पॉन्ड नंबर 5 he has also expired.
उसको लगा तुम ही
उसका substitution file है।
उसके बाद
रिस्पॉन्ड नंबर 5 का
Yes, 1, 2, 3, 1, 8, 25.
1, 2,
1, 2, 3, 1, 8.
ये है तो आइए फाइल किया 4/9 को
इनको नोटिस हो गया है?
ना
कहाँ नहीं हुआ है?
नहीं। IA number 12317 of 25 has been filed for substitution of respondent number 5, who is said to have expired on 2/9/2015 with a prayer for condonation of delay and also setting aside abatement. ये तो कॉन्डोनेशन ऑफ डिले का है और दूसरा सब्स्टिट्यूशन का अलग से होगा। हाँ, ये वो है कॉन्डोनेशन ऑफ डिले एंड सेटिंग असाइड। नाउ IA number 12318 of 25 has been filed seeking substitution of respondent number 5, whose the details of whose legal heirs and successors have been mentioned in paragraph 7 of the interlocutory application. 7 and 8. ये तो अलग अलग क्यों है?
हुजूर जब वो 5 का नहीं किए थे लास्ट डेट के सुनवाई में तो हमने ऑब्जेक्ट किया
कौन सा?
कि 5 का तो उसी पर ही फाइल किए।
Just a moment. 7, 8 में तो सेम नाम लिखा हुआ है ना?
हाँ, ये मारे हुए भी टाइप हो गया।
7, 8 में तो
सेम ही है, सेम ही
सेम है।
सेम। दो ही कोई सेम महेश्वर मुर्मू है, ज्योति दो ही।
और कौन मर गया? अच्छा ओके।
मांडो देवी मरेगी।
अच्छा, और मंजू देवी का कोई लीगल या सक्सेसर नहीं है?
यही है, वाले बच्चा वही का है। रस्का का वाइफ है, इस दोनों बच्चा मिटर की।
Just a moment. Proposed legal heir and successors, as mentioned in paragraph 8, they are altogether 3 numbers, but Mango Devi has already expired. Let notice be issued to the proposed legal heirs and successors of respondent number 5 in IA number 12318 of 25 and IA number 12317 of 2025 through the concerned police station. इसका भी आप रिक्विजिट फ्राइडे तक फाइल कर दीजिए। सारा का रिक्विजिट फाइल कर दीजिए स्पीड पोस्ट से, स्पीड पोस्ट एंड दिस थ्रू द कंसर्न पुलिस स्टेशन दोनों, ठीक है? एंड देन वी पोस्ट इट ऑन अ डेट, लेट देम कम, उसके बाद एक साथ सुनवाई करेंगे। बस उसके बाद टाइम नहीं देंगे, अपीयरेंस के बाद टाइम नहीं देंगे, किसी और के मरने का इंतजार नहीं कर सकते, राइट? किसी और के मरने का इंतजार नहीं कर सकते हैं रिकॉर्ड पर, उसके बाद हम टाइम नहीं देंगे। एक बार केस रेडी होने के बाद हम टाइम देंगे। पोस्ट ऑन 30th October. हम बोले हैं आप उसको करिए करेक्शन, मेमो ऑफ अपील में से रिस्पॉन्ड नंबर 2 का आईए से मिला के करेक्शन करिए, उसके बाद ही उनको नोटिस जाएगा।
इंस्पेक्शन कर लेते हैं।
इंस्पेक्शन क्या अभी बैठ के करेंगे?
एरिया पुलिस को अलग से फाइल कर देंगे, टाइप को बढ़िया रहेगा।
क्या चीज?
टाइप करके अलग से फाइल कर देंगे।
नहीं नहीं, आप इसको एडिट करिए।
14 7
तीन नाम आपको मिसाना है फिर।
और ये से 14 7 9 ऑर्डर में दो रिस्पोंडेंट को भी ऐड करने के लिए ऑर्डर दिया
कोई बात नहीं, हम लोग ऑर्डर कर दिए सबको ऐड
जी।
कर दिए। वो कुछ एरर हो गया होगा उसमें।
On the dating for hearing item 2, second appeal 85 of 1994.
किनका एडजर्नमेंट रिक्वेस्ट है?
But Mr. Manjul Prasad is not well known.
यस टू आगे डिस्कस
Yes, sir.
आपकी तरफ से उनकी तरफ से।
He responded.
Respondent 6 to 8.
सब्सटेंशियल क्वेश्चन ऑफ लॉ क्या है? मुस्लिम लॉ।
Muslim law notes and substantial question of law notes we have filed an IA for framing additional question of law. On the last occasion, they were directed to file
पहले
a
तो
reply.
बना होगा ना?
Sorry, हाँ पहले बना है
बताइए कौन सा?
6895.
और आइए आपने क्या फाइल की?
Yes. But IA
Have you responded to the IA? Have you seen the IA?
Yes, sir, Lordship, we have filed a reply.
they have just filed a reply. They have just
बताइए।
yes.
What
But
is the
see
addition?
paragraph 5 notes. Let this.
Yes.
But the additional question of law which we propose is whether the plea of previous partition set up by the defendant based on mere inference and without any proof of the same can this entitlement this yeah
This is covered by the substantial question of law already framed.
yes.
Yes. Next.
Then your second is whether in spite of clear-cut admission of the defendant in the written statement filed by defendant admitting that lands of Khata number 36, 11 and 110 are joint family property and liable for partition, the suit of the plaintiff would have been dismissed.
Who said that there was a previous partition? Plaintiff or the defendant?
No, plaintiff had filed a suit for partition.
Okay.
Lord, there are altogether Lord 6 khatas. 3 khatas are recorded in the name of common ancestor. 3 khatas are recorded in the name of different defendants.
Okay.
So, Lord, so far as these 3 khatas are concerned, 36, 11 and 110, these 3 khatas, Lord, there are altogether 5 or 6 written statements, in which Lord 3 of the written statements specifically state that these lands are joint and liable for partition. So therefore, Lord, that question of law we are proposing, that once there is a clear-cut admission of the defendant in their written statement that these khatas are joint, because it is a
Admission
judgment
by
of
only some of the defendants.
admission of Lord 2 of the defendants are subsequent purchasers who are interveners in the suit.
Okay.
They are not related. They have not said so, but they are not in the family tree because it is a partition suit.
The partition suit was for properties including this khata
Yes,
number?
including these khatas.
दिखाइए एडमिशन दिखाइए एलसी एडमिशन कौन सा पैराग्राफ में एडमिशन
Lord, may kindly take a written statement of defendant number 1, 9 and 10.
and you read it
Yes.
para number
This is para number 6. May I please?
read it
Yes. That the suit is not maintainable or for all the lands mentioned in the schedule of the plaint. In fact, the lands of Khata number 36, 11 and 110 are common properties of the plaintiff and defendant, and the plaintiffs are entitled to the share to the extent of 1/5 and the defendant are jointly entitled for 4/5 share in the rest of the lands. They have got no interest, right or title or possession as other lands or self-acquired lands of other co-sharers on their own separate funds and as mentioned in the succeeding paragraph. So far as these three khatas are concerned,
How the court has dealt with it?
Lord,
Has the court partitioned all these properties also?
Lord, the trial court have partitioned all the properties, but the appellate court, Lord, dismisses the suit with respect to the entire khatas.
Let's see. You are the plaintiff.
And the plaintiff.
So
Yes.
the trial court has partitioned all the properties.
All the properties,
Okay.
taking into account that these khatas are joint, common ancestor, other khatas which are recorded in the name of different defendants were acquired during the lifetime of common ancestor.
We are only concerned with these properties as of now for additional.
Yes. So far as these is concerned,
Just a minute.
yes.
The partition decree
Yes.
has been set aside.
Have been said.
So therefore, admittedly, there is no partition so far as these properties also.
Yes.
So now you say that at least these properties were required to be
They are required to
partitioned
be partitioned.
on account of the
Admission of the defendant in the written statement.
On this substantial question of law, what do you have to say?
With respect
Who are you?
the respondent number 10B and 10C. With respect to the Lord, the contention lies in that the some property are not joint and some property have been not partition. There is a finding in para 7 of the appellate court judgment that the lands with respect to three khatas have already been partitioned. Or
Which
there
three
is a
khatas?
previous partition.
Which three khatas? You see, there are two parties.
Three.
Just a moment.
Three khatas.
You are the defendant.
Yes.
Right? They filed a suit for partition, including these properties.
Yes.
You filed a written statement.
Yes.
You filed a written statement
Yes.
saying that these three plots were not partitioned.
In our written statement.
In your written statement, you are opposed.
There is an admission that the lands of khata number 36, 11 and 110 were joint. Although there was a previous partition, but there is it is an ancestor property, joint property. So there is a abatement in the in the during the time of giving evidence. It was averred in the evidence that if these properties were partitioned, then these defendants will have no objection. But the lower appellate court have dealt with that, and these type of statement having had no bearing on the case of the plaintiff.
How?
So this is the finding. May I
We'll deal with it. We'll deal with that. It is an important fact. at least
In paragraph number,
you are the purchaser of the property.
No,
No, you are not the purchaser.
no. We are also not the one of the brothers.
So therefore, if you are also one of the brothers,
Lord, there is a
who
fine.
is representing the purchaser of the property?
No,
We are all
nobody is
purchasers.
purchaser here. Nobody.
No, intervener जो है
इंटरवेनर तो
Intervener,
दूसरे खाता
Lord,
नब्बे
they
दूसरे खाता के
हाँ, खाता
वो
90
खाता
में
नहीं, ये तीन खाता से रिलेटेड
खाता 90 में उनका सिर्फ इंटरेस्ट था, but with respect to that खाता 90 there is a finding of the lower
So
appellate court.
therefore, it was the case of both the parties who are appearing today. In the written statement that this property has not been partitioned.
No, Lordship, it has been partitioned.
It
We have
there is a
taken-
finding of the court, appellate court that
Finding
it-
we go beyond the
already there is
pleadings.
a already previous partition,
No,
so it is
how
not
the-
required to be
How the
partitioned.
court will enter into this when there is an admission that this property has not been partitioned?
With respect to only these three khatas.
Yes.
And with
So
respect to
we
the
are
other
we are
khatas,
proposing substantial
khatas-
question of law only in connection with these three khatas.
the learned trial court has not partitioned the property, presuming the land to be a joint family property.
That's right.
Under the theory of the concept of the Hindu law.
We'll
But
see
these things has all things have been dealt with by the appellate court. saying
There
that-
is a dealing of the appellate court with regard to 36, 11 and
Lord,
110.
page 39 of the appellate court judgment, internal page.
You can see the point number 3.
Lord, from the last two lines, Lord, page number 39 of internal page. From the last two lines of that page.
Just a minute. Page number 39, last, the evidence of
The evidence of DW15 appearing in para 8 of that, he has no objection if the land of khata number 36, 11 and 110 are repartitioned. It is itself can never be a ground for reopening the partition of the land. Khata number, line of khata number 36, 11 and 110 in absence of any proof on behalf of the plaintiff respondent of the circumstances in which such unequal division came to made and
who
it
is defendant number 15? DW15 is who is DW?
DW15 is the evidence whether he was a party or not.
Can any evidence be laid beyond the pleadings? He is talking about repartition.
तो पूरा देखना होगा.
वही ना, इसीलिए substantial
evidence are beyond the
इसीलिए
pleading.
substantial question of law बनाना पड़ेगा.
May I
When in
submit
the pleadings there is an
And with
admitted
respect to the other
When in
khata,
the-
there is a specific finding that these lands are the self-acquired property
But
of
you
only
forget about
the
rest.
sons of the
You forget
Let
about
us
this.
speak one by one.
on account of an admission with regard to these three plots. Can
It does
still
not-
the court say that it has already been partitioned?
Yes.
Lordship, in our reply para 5, Lordship, we have stated that in para 8 of written statement filed by all the co-sharers, Lordship, it was not the exclusive property of Sheikh Faga, the common ancestor. It was jointly recorded in separate possession of each co-sharer to the branch, and partition between them had already been noted in the remark column of Sheikh Faga 1/3 share, which devolved upon his heirs who had partitioned the same. This aspect has been dealt by the learned appellate court in para 20 to 22 of the judgment.
Therefore, the statement of these defendants that it could be subjected to partition does not tally with the records of the case.
Lordship, this written statement that we have filed, we have not stated anything that these are the joint properties still in the
Who are you?
So they are for 1 to 10, 1 to 8. The
Who are 1
co-sharers.
to 8? Co-sharers.
Co-sharers.
And this written statement आपने किसका पढ़ के सुना है?
Oh, 1, 9 and 10.
आप
Not
बोलो
the plaintiff.
हाँ, नोट या इंटर से डिस्प्यूट भी नोट जिन लोगों के बहुत सारे हैं, इसीलिए नोट 1, 2, 3, 4, 5, 6 WS फाइल हुआ इस केस में.
पहले एक
Oh,
joint
wow, not I have just now placed not WS of 1, 9 and 10. Your Lordship may kindly see WS of 1A to 1C also.
Can you show me the finding in connection with this particular property, whatever you have stated?
Finding it as page number, para number 20. 20 or what? In para 20 it has been held. This point is therefore decided in favor of the defendant appellant and the defendant respondents excluding the intervener defendant and against the plaintiff respondent. It says with respect to the खाता number 80, 88,
80 में कहाँ पहुँच गया? 80 का बात नहीं कर रहे।
19 से पढ़ा जाए, पैराग्राफ नंबर 19 से। पेज नंबर 14 में।
पैरा 19 तो दूसरा खाता।
उसी का उसके
80, 88, 89, 90
उसके जस्ट उसके ऊपर में है।
Faga was unfair and fraudulent, Lordship. Mass.
खाता नंबर 36 धारा और 110 के बारे में फाइंडिंग है। पारा 19 के जस्ट ऊपर में राइटिंग है।
You have executed sale deed also in connection with this property.
But few properties have been sold. Exhibit D. On
Exhibit
that
D.
ground, Exhibit D. On that ground,
Like
the court
exhibit D
says
निकालिए तो।
that
Does the exhibit D talk about previous partition?
no.
Let me just check.
Yes.
Let's frame an issue that whether the learned first appellate court was justified in reversing the finding in connection with these three properties. The finding has been reversed. Particularly, और इनका जो pleading है उसको देखते हैं. Then we will decide it,
Yes.
right? Because there is a reversal on this
Yes,
aspect,
there is a reversal.
clear reversal on this. Just a moment, let me just. IE number 12418 of 2025. In essay number 85 of 1994 within bracket R, the learned counsel for the parties are present. This petition has been filed for framing additional substantial question of law. So far as the first proposed additional substantial question of law is concerned, the counsel for the applicant submits that the same would be covered by the substantial question of law already framed by this court, and he does not want to press it. So far as the second proposed substantial question of law is concerned, he has referred to paragraph 6 of the written statement of defendant number 1, 9 and 10,
1, 9 and 10.
and has submitted that these defendants had admitted in the written statement that the only property which was available for partition was belonging to khata number 36, 11 and 110. He submits that since there was an admission on the part of these defendants that this property could be subjected to partition, the learned first appellate court was not justified in reversing the finding, at least in connection with these three properties. The learned counsel for the respondents have opposed the prayer and have submitted that the learned first appellate court has considered the materials on record to come to a finding that even these properties were already partitioned. After hearing the counsel for the parties, this court is of the view that a substantial question of law arises in this case. As the in the light of the written statement.
There were 3 sets of written statements. Some of the defendants who had filed written statements with us, they had separated and then they had filed unwritten. So it may be frame watching.
The following additional substantial question of law is here well framed. ये as it is रखते Roman ठीक है language भी सही है.
It's only in my submission notes. Your Lordship may kindly add notes.
Roman 3.
Yes,
Roman 3.
but in this only, in my submission, Your Lordship may also add note WS of defendant number 1821C, in which para 1 is their admission.
इसी में
हाँ, same. इसी को हम justify करने के लिए note. There are
किसको justify करें?
yes, the question of law proposed one, Roman 2. क्योंकि मेरा
Apart
submission
from written statement of 1, 9 and 10.
10, it is WS of defendant 1A
And
and
also
1C.
Written statement of 1A
A
to
to
1C.
1C, paragraph 1.
Paragraph 1.
Yes.
That's it. Roman 3 बताइए.
Yes. But so far as Roman 3 is concerned, but it was the case of the parties that these khatas, 88, 80, 88, 89 and 90, were joint family property, although recorded in the name of separate defendants, but they were acquired during the lifetime of common ancestor, that is Sheikh Fat, who died in 1935. The only document which they have shown is that khatiyan, by which they say ये सब defendant लोग के नाम पे है, that is a revisional survey khatiyan notes, that is prepared in the year 1935-36.
How
Now,
did they acquire that property?
sorry.
By selling?
No. They say कि हम लोग को ये जो है settlement हुआ है और हम लोग को अपना मिला, हम लोग अपने से acquire किया. Now there are specific cases that till their father was alive, that is 1940, they were joint, and there was no separate business. So
And this khata has been this record
yes,
was prepared when?
1935 RS prior to 1940. So it is their own case in the written statement that till father was alive, we were all joint till 1940. So once it is their admission that till my father was alive, the common ancestor Sheikh father was alive till 1940, whatever acquisition was made from the common fund, because their own case is that जब तक हम लोग के father 1940 तक alive थे, तब तक we were all joint. It is only that कि उसके बाद हम लोग अपना division कर लिए, क्योंकि वो few properties are recorded in their name, no doubt. There are.
What do you have to say to this?
Defense witnesses have stated that we were doing a business of weaving, and from that income we had purchased.
ये नहीं चलेगा.
But there,
You ought to kindly take a written statement.
Joint means what? They were also doing the work of.
So joint family business. If a property has been acquired from a
Weaving
joint
is
family.
a joint family business.
So sorry.
Weaving is a joint family business.
Yes, it is a joint. Lord, it is the written statement. Your Lordship, kindly take WS of 1, 9 and 10. Let us read this.
बताइए 87, 88 के बारे में क्या बोलूं?
हाँ
पैरा 9
इसमें तो आप पैरा नंबर कौन सा दिखाए थे?
सॉरी इसमें पैरा 6 नोट
पैरा 6।
पैरा 6 दिखाते कॉमन है नोट में काइंडली टेक नोट फर्स्ट डब्ल्यूएस ऑफ डिफरेंट 1 to 10
इसमें पैरा 6 में तो ये है ही नहीं
सॉरी
जो आप अभी पढ़ के सुनाए।
नहीं
वो डायरेक्ट पढ़ रहे हैं होती है WS।
हाँ तो डब्ल्यूएस है दिखाते हैं कहाँ है
अच्छा WS
नोट डब्ल्यूएस डिफरेंट नंबर 1 to 10 का पहला दिखा
पैरा नंबर
1 to 10 नोट दिखा है छोटा डब्ल्यूएस है लेट अस सी व्हाट इज
1 to 10 आप कौन सा पैराग्राफ हमको पढ़ के सुनाए थे?
नोट हम दिखाए थे डिफरेंट डब्ल्यूएस ऑफ 1, 9 and 10 पैराग्राफ 6
1, 9 and 10
1, 9 and 10 paragraph 6
एक सेकंड लेट मी जस्ट चेक
yes yes
पैराग्राफ 6 ओके
Yes.
हां
have you lordship
इसका
brought
ना
it?
पैराग्राफ 6 को पंकज जी जब कोट कर देंगे है ना हम इसको फ्लैग कर दे रहे हैं वी जस्ट कोट दिस और इसके बारे में क्या
हाँ और WS प्लस डिफरेंट 1A और 1C का जो हमने बताया वो भी एक बार चेक
नहीं ठीक है
उसका पैराग्राफ 1
1A and 1C
1A to 1C प्लस पैराग्राफ 1
जब 1 इसमें आ गए तो लोग उसके अलावा क्या है कोई
तो
अलग
सब्स्टिट्यूशन के बाद उन लोग फिर आए और
एक ही
फिर
बात है ना इट डजंट मेक एनी डिफरेंस कोई दूसरा प्री तो ले नहीं पाएंगे इनका बताइए
यस अब देखा जाए WS ऑफ डिफरेंट नंबर 1 to 10
1 to 10
1 to 10 व्हाट इज देयर केस
88 वाला बताइए
हाँ उसी पे होगा मैं प्लेस दिस पैरा 1 onwards that the suit is not maintainable
ये स्पेसिफिक 88 वाला बताइए
हाँ तो ये चार जो खाता है उसके बारे में इनका केस होगा ना नोट्स कि ये खाता मेरा है हम अपने फंड से एक्वायर किए हैं क्योंकि हाँ ये वही तो हम दिखाना चाह रहे हैं नोट इन द एंटायर रिटन स्टेटमेंट जो लॉर्डशिप में विल फाइंड हाँ टोटल नोट 17 पैराग्राफ्स का WS डिफरेंट 1 to 10 और लेट मी जस्ट क्विकली रन थ्रू दिस पेज वाइज देखते हैं नोट पैरा 1 2 3 4 में कुछ नहीं है इसके बारे में then note your lordship में kindly flip the page note next paragraph 4 5 6 7 में कुछ नहीं है paragraph 8 में note जैसा कुछ नहीं है now note paragraph 8 में your lordship में kindly पेज 3 8 का मिडिल नोट खाता 80 जो है उसके बारे में क्या स्टेटमेंट है इनका मैं प्लेस पैरा 8 खाता 80 नोट्स मिडिल में हाँ खाता 80 of village Tigoi has wrongly been included in the partition of by the plaintiff. This land exclusively belonged to Sheikh Dinu who had taken it on settlement from the ex-landlord on 29/9/1935. So your lordship may kindly mark this date 1935 is the date when they say कि we have taken it on settlement. Oh, 1935. Now your lordship may kindly allow me to read. And since he has paid full salami later on 29/10/1985, he was
29/10/1943
1943
43
नहीं
43 है फुल सलामी ऑन 29/10/1943
okay let us see note 43 he was granted हुकुम क्योंकि हम लोग को जो मिला है कॉपी को काट करके 35 किया हुआ है
इसमें नहीं है
अच्छा ठीक he was granted हुकुमनामा and later date and he has exclusive right and possession thereon and he was succeeded by defendant number 2 alone who is in possession of the same in assertion to his exclusive right. None of the plaintiff or other defendant had any right or possession therein. Khata number 11 of village Hesal and khata number 110 of village Kargil belong
हुकुमनामा of the year 1935 was issued in whose name?
Not they say it was issued in the name of Sheikh Dinu.
Sheikh Dinu.
Yes,
Who is Sheikh Dinu?
Sheikh Dinu is ancestor of defendant number 2.
And you are seeking partition of property of
But I am seeking partition of property of 80, 88, 89 and 90.
no, I just want to
property of Sheikh
common
Father.
Sheikh
No, Sheikh Father is a common
as well as his sons.
Not मेरे पास ये जो last week
Plaintiffs are the sons of Charku, who is son, one of the sons of Sheikh Farah, and these Sheikh Dinu, Sheikh Bula, Sheikh Sabri, and Sheikh Sadali. There are other 4 sons from the second wife. The plaintiffs are coming from the first wife, and the defendants are from the second wife. There are 5 brothers, right? 5 brothers. तो जो सेपरेट प्रॉपर्टी कर रहे हैं ये सिर्फ 5 ब्रदर्स के नाम से,
हाँ हम तो यही बोल ही रहे हैं
ब्रदर्स के नाम से, सॉरी
हम तो
ये
यही बोल
इनके
ही
नाम
रहे
से
हैं
है नहीं, शेख फागा के नाम से है नहीं, वो ज्वाइंट प्रॉपर्टी नहीं, तो इसीलिए फाइंडिंग दिस प्रॉपर्टी ऑफ खाता नंबर 88, 89, 90 आर सेल्फ एक्वायर्ड प्रॉपर्टी ऑफ दीज 4 ब्रदर्स, Sheikh Dinu, Sheikh Bula, and out of that one of the property is only in the name of Sheikh Dinu. और ये जिस
Lord, may I pass on this genealogical table which will clarify notes किसके किसके नाम पे कौन सा खाता रिकॉर्डेड है.
ये बहुत ज्यादा फैक्चुअल है.
नहीं फैक्ट में नोट्स क्योंकि जो प्रॉपर्टी जॉइंट है उस पे तो नोट्स क्वेश्चन ऑफ लॉ फॉर नोट्स जो प्रॉपर्टीज इनके नाम पे है व्हेन इट इज देयर ओन केस दैट इट वाज एक्वायर्ड इन द ईयर 1935
No, it was not acquired in the year 1935. Technically, it was acquired only in the year 1943.
no notes
The salami was paid in the year 1943.
they say settlement of from the excellent
Maybe.
on the settlement is the date when it was settled it is their case
सलामी ही दिया गया 1943.
बट सलामी तो पेमेंट हो लेकिन जो सेटलमेंट हुआ इनका अगर केस है 1935 में हमको सेटलमेंट हुआ और इनको जो ये
इंडिविजुअल नाम से किसके नाम से सेटलमेंट हुआ?
हाँ इंडिविजुअल नाम से मिलोट ये हुआ है एक हुआ है खाता 80 में है मिलोट डिफेंडेंट नंबर 2 3 to 8
80 में डिफेंड नंबर 2 3 to 8.
हाँ 3 to 8 88 में 1 2 and 3 to 8
8.
89 में डिफेंडेंट नंबर 1 to 10 and 90 में डिफेंडेंट नंबर 1 to 10 and डिफेंडेंट नंबर 11 to 13 so these
इंडिविजुअल नाम से सेटलमेंट हुआ.
individual नाम से settlement हुआ तो these settlements were made Lord, prior to death of father 1940 that is the date when their case is that till 1940
If it was made prior to that date,
yes Lord.
right? Then the settlement ought to have been in the name of their father.
This is our case that Lord, defendant number 2 Sheikh Dinu he was the elder brother father was old this is our specific case in the play
Yes, but no substantial question of law arises. Based on finding of the learned first appellate court on this.
in para 15 there is dealing with respect to all the documents they exhibited para 15 onward सब separate self acquired property है इसके बारे में para 15 में सब एग्जिबिट के बारे में चर्चा है.
लिखिए. So far as the third substantial question of law, proposed substantial question of law is concerned, the counsel for the appellant has submitted that khata number 80, 88, 89 and 90 were also joint family property, as they were acquired during the lifetime of the common ancestor Sheikh Fagi, who expired
in the year 1940
in the year 1940. He submits that the settlement was made with respect to khata number 80 in favor of defendant number 2, 3 to 8, with respect to khata number 88 in favor of defendant number 1, 2, 3 to 8, with respect to khata number 89 in favor of defendant number 1 to 10, and with respect to khata number 90, in favor of defendant number 1 to 10 and 11 to 13 through separate hukumnamas with respect to each of the defendants. Correct?
After 80 stands recorded only in the name of defendant 2.
But there are interstate
Whatever,
disputes
yes.
also.
Right. Just a minute. The learned counsel for the appellant has specifically submitted that since the settlement was made during the lifetime of Sheikh Fagu, who expired in 1940, therefore these properties are bound to be treated as joint family. Right? The learned counsel for the respondents has opposed the prayer and has submitted that separate settlement was made, and even if it was made during the lifetime of Sheikh Fagu, the same does not mean that it is joint family property. Admittedly, those properties were not settled in the name of Sheikh Fagu. They have also submitted that the learned first appellate court has examined this aspect of the matter in detail and returned a finding that the settlement made in connection with plot number khata number 80, 88, 89 and 90 were self-acquired property. After hearing the counsel on the third proposed substantial question of law, this court is of the view that the learned first appellate court has recorded finding after considering the materials and no substantial question of law in this connection arises. Fourth one.
Note fourth one is, note may kindly take note appellate court judgment paragraph 48.
Yes.
Page 48, sorry.
Page
48.
running page 40.
Running page 48. No, no, internal page 48.
Internal page.
Yes.
Into substantial question of law. It was general whether judgment under appeal is vitiated for purpose and
The perverse over the substantial question.
Perverse मतलब क्या बोलेंगे?
Yes. Note in the finding, the appellate court have recorded that PW6 in para 22 have stated. May I place this? In para 22, I am placed. Have you not recorded?
Yes.
Yes. In para 22, PW6, the plaintiff respondent has further admitted that the aforesaid documents in the name of Sheikh Paga are in his custody. Surprisingly enough, no document standing in the name of Sheikh Paga evidencing the fact of acquisition of lands of khata number 88, 89, 90 and 80 has been brought on record by the plaintiff respondent for the reasons best known to him, and no explanation for the non-production of such document is also forthcoming on behalf of the plaintiff respondent. Had the document been brought on record by the plaintiff respondent as PW6, the plaintiff respondent claiming himself to be in custody of the same, the matter in controversy with respect to thereof might have been decided
What
on
is
the.
so perverse about it?
Yes, but court records that PW6 have stated that the document of settlement of these khatas are in custody of PW6, and therefore the court says कि अगर वो PW6 के कस्टडी में है वो प्रोड्यूस किए होते तो उनके खिलाफ जाता, therefore adverse inference is being drawn against PW6. Plaintiff.
No, the court is saying that PW6 has not produced any of these documents.
Yes, because why? Not the map. Your
Has he
Lordship, again, the
produced?
plaintiff respondent claims himself to be in custody of the same.
Yes.
Yes, PW6 says कि मेरे कस्टडी में है, और इसीलिए कोर्ट बोले कि अगर PW6 ये बोले कि मेरे कस्टडी में ये डॉक्यूमेंट अगर ये प्रोड्यूस किए होते तो इनके खिलाफ जाता, therefore adverse inference ड्रॉ किया जाता. Your Lordship, may kindly see PW6 का evidence.
नहीं.
PW6 क्या बोले? No, but it is perverse. Your Lordship, may see PW6 का evidence क्या बोले? PW6 ऐसा बोले ही नहीं कि मेरे कस्टडी में.
He has not stated.
No, therefore it as mentioned, it is perverse. Your Lordship, may see PW6 का evidence.
नहीं तेरा PW6.
Para 22, which has been quoted.
PW6 इतना चिल्लाने का जरूरत नहीं है, बाधा
But-
नहीं है. Please.
Your Lordship is saying
हम आपको सुन रहे हैं ना?
Yes, yes.
बस. That is enough. Don't shout at the top of your voice. I can shout louder than you.
Yes, definitely. I'm sorry.
PW6.
May I please?
पूरा पढ़िए.
But he refers to para 22.
खाली पैरा 22 would be persistent relation.
Yeah. इस बात में मैं मुदई नंबर 1 हूँ. मुदई 2 और 3 मेरे भाई हैं. मुदई 4 और 5 मेरी बहन है. दाले नंबर 1 मेरे चाचा थे. मुदई व मुदाले 1 से 10 तथा फागा के खानदान के हैं. मुदई 11 से 15 तक हुसैनी के खानदान के हैं. फागा की 2 पत्नी, पहली झालो थी. फागा और झालो से एक लड़का चरकू था. दूसरी पत्नी दुबई थी. उससे फागा का 4 लड़के थे जिनका नाम दीनू, भूखा, शाहबली और शाहदली थे. इन 4 लड़कों ने के वारिसान मुदई संख्या 1 से 10 है. कतरारी जमीन पहले शेख फागा का था. खतियान भी उनके नाम से बना है. यह सब जमीन अभी तक इजमाल है. हाल सर्वे कई याद है. हाल सर्वे के समय फागा के तरफ से दीनू नाप करवाता था. चूंकि वह सबसे होशियार लड़का था, 2-4 जमीन का नाप दीनू ने सर्वे में अपने नाम से दर्ज करा लिया. उस खाता नंबर 88, 89, 90 है. वह 3 खाता का जमीन भी फागा का ही है. दीनू की अपनी जमीन नहीं थी. दीनू और उसके भाइयों का अपनी अलग आमदनी का जरिया नहीं था. पूरे परिवार का आमदनी खेती से ही था. खाता
Just pause. He is making a statement that these settlements were made in the name of Sheikh Faga.
Yes.
And then he has said that he got it recorded in his name. So settlement was made in the name of Sheikh Faga. Correct?
But
As per his evidence.
As per his evidence, he said
Settlement was made in the name of Sheikh Faga.
Sheikh Faga with respect to.
The settlement has been produced.
Sorry.
The hukumnama or the settlement has been produced in individual names.
Yes, yes.
They have
No,
been exhibited.
They have been exhibited.
It was also, they were all in the name of individual persons.
Not so far as these 4 khatas are concerned, they were in the name of these
Individual
dependents.
persons. So we
Dependent.
are only concerned with this.
Yes,
Because so far as the remaining 36 and all, we have already framed a substantial
Yes.
question of law.
yes,
So what survives here? He is saying
yes.
that these documents were issued in the name of individual, in the name of Sheikh Faga, right? But these documents, firstly, he has not produced it, but however, it has been exhibited in the record, and they have been shown to be in individual name. Then
Yes.
what is the material to come to a conclusion
Yes.
that it was issued in the name of Sheikh Faga?
No, the court records here, these documents were in possession of
It's
PwC.
immaterial. Whosoever has produced it, it has been exhibited.
It has been exhibited.
It makes no
Therefore,
difference. Whosoever has
no,
produced
no,
it.
the court says
No, that is not the only reason to come to a conclusion.
But
We cannot.
that might not be the only reason, but that is one of the reasons.
Maybe.
Because the court records the
We'll see
finding
that, we'll see
that
that.
adverse inference has to be
We'll see
drawn.
that. We'll see. Okay.
Because
We'll see that. You just listen to that. With respect to the, what do you have to say to this? With respect to the fourth proposed substantial question of law, the learned counsel for the appellant has submitted that.
Can you Lordship allow me 1 minute just to place क्या adverse inference पे क्यों मेरा case throw out कर रहे हैं? This is the finding recorded by the appellate. क्योंकि उसी के बाद बोलते हैं accordingly an adverse inference has to be drawn against the plaintiff respondent regarding acquisition of the lands of khata number so and so by Faga as alleged on this score alone. The case of the plaintiff respondent is in respect thereof has to be thrown. So therefore he draws an adverse inference.
We'll see that. What are the exhibits of these hukumnamas? They have been exhibited?
Yes.
All of them have been exhibited?
Yes.
Hatiyan have also been exhibited in our own.
Hukumnamas have also been exhibited? The learned counsel for the appellant, while referring to the evidence of PW6, has referred to the discussion in paragraph number
सबका हुक्मनामा एग्जिबिट नहीं हुआ. एग्जिबिट खाता 89 एंड खाता 90 का हुक्मनामा एग्जिबिट नहीं.
In paragraph number 21 of the learned appellate court's judgment, and has submitted that it has been incorrectly recorded in paragraph 22 that the plaintiff had admitted that the efforts, that the hukumnamas that the documents in connection with khata number 88, 89, 90 and 80 were in his custody, and that he had not produced those documents, and by wrongly recording the same, an adverse inference has been drawn with respect to khata number 80, 88, 89 and 90.
Should I correct myself? Hukumnamas have not been produced for all the khatas, but khatiyans have been produced for all the khatas.
Paragraph 22. This court has seen the evidence of PW6 and paragraph 22. And in paragraph 22, it has been recorded that except khata number 36, the properties, all other properties were purchased by Sheikh Farouk. And he has stated that in his presence, the property was not purchased. He has also stated that the document was registered document and it was in the name of Sheikh Farouk, and he has the said document.
वो कागज फागा के पास है।
वो कागज मेरे पास है।
नहीं
Yes.
वो कागज फागा के पास है।
कहाँ से पढ़े थे?
हाँ पैरा 22 मेरे पास नहीं वो
वो
कागज
कागज मेरे पास है।
what is reading from judgment
Yes, yes, I'm reading from the deposition. दिखाइए। I can show it to you. Last line. वो कागज मेरे पास है।
इसमें तो मेरे है, इसमें फागा नहीं।
अब कुछ भी आपने लिखा है तो हम मुझसे नहीं पढ़ेंगे ना आपके
नहीं
डॉक्यूमेंट्स।
हम कहाँ बोल रहे हैं लेकिन मेरे पास जो है वो इसमें
जो भी होगा, I do not know. You have seen it?
Yes, I've seen
Be
that.
satisfied with that. However, it is admitted that neither the registered document, neither the original registered document nor any certified copy has been exhibited before the court. Correct? In view, this court also finds that the evidence of PW6 has been discussed threadbare, and accordingly no substantial question of law arises so far as the fourth proposed substantial question of law is concerned. हो गया, आइए disposed of एक substantial question of law बनाएं. That is it. So additional.
No, I was emphasizing because जो सर्टिफाइड कॉपी हम लोग को सप्लाई हुआ उसका वो कागज फागा के पास है एब्सोल्युटली नॉट डिफरेंट व्हाट इज देयर क्योंकि यहाँ पे मतलब आई एम आल्सो सरप्राइज्ड
There is no perversity in the recording of evidence of PW6.
वो कॉपी किया हुआ है, रॉन्ग है इससे।
कोई बात नहीं.
हाँ लगता है क्योंकि ये जो है इसमें एकदम स्पेसिफिक
आपने टेक्स्ट पढ़ लिया ना,
वो पढ़
बी सेटिस्फाइड। इसको जो है ना पैरा नंबर 22 को अगर पढ़ा रहा है ठीक से तो बाकी रेस्ट तो इसको कॉपी कर। एक सेकेंड, द लर्नड काउंसिल हैज आल्सो read the paragraph 22 of PW6 from the records received, and it has been specifically recorded therein inverted comma वह कागज मेरे पास है। चलिए, और इसमें कोई कटिंग भी नहीं है, राइट? इसमें कोई कटिंग भी नहीं है कि साथ बाद में कोई कुछ किया है। हो गया? अब बहस कब करेंगे ये बताइए? इतना कहानी इसलिए की कि आप जल्दी से बहस करिए।
इसको
94 का सूट कब का है? आपके जन्म के पहले का कि बाद का? कब का सूट है बताइए? Just prior to your birth or after? You were not born, no? तो आपके जन्म के पहले का कहानी।
इसलिए लोग दिवाली तक कहीं
आपको कभी जन्म नहीं हुआ होगा।
नहीं।
कौन सा दिवाली चाहिए आपको? एक आध दो लोग और मर जाएंगे इसमें।
नहीं।
पुराने रिकॉर्ड में हमको मरने का बहुत चिंता है। कब करेंगे ये बताइए?
इसको लोग 30 अक्टूबर के दिन दिवाली के बाद छुट्टी बाद
दिवाली
कंटिन्यूअस बंद है 30 अक्टूबर।
अरे भाई लोग को दिवाली मनाने दीजिए।
हाँ तो इसे बोल
दिवाली के पहले करिए।
दिवाली हम लोग को मना दी लोग दिवाली 30 अक्टूबर का
नहीं, इतना पुराना हम इतना लंबा डेट नहीं देंगे। हम छुट्टी के जस्ट बाद का डेट देंगे। आप लोग भी होमवर्क करें, हम भी होमवर्क करेंगे। हमारे पास भी सीए भी है।
और छुट्टी के बाद डिफिकल्टी छुट्टी में है नहीं तो बड़ा दिक्कत है।
छुट्टी में आप नहीं है। ये कौन सा आपको अपना रूटीन बना?
बट उसको पढ़ने में तो टाइम लगेगा।
कुछ टाइम नहीं लगेगा, पढ़ लिए।
तब मैं उसको 14 है।
Ready? With the consent of the learned counsel for the parties, post this case for final disposal on 14th of
एक टाइम जरूर
on 14th of October. Parties to prepare short synopsis with respect to the substantial question of already framed. ऐसा बनाइएगा फैक्ट फैक्ट्स और टैली करके जब कोर्ट में लिखा, ठीक है? जजमेंट्स विद सपोर्टिंग जजमेंट्स इफ एनी by 10 तारीख तक।
Item 3, second appeal 484 of 2003.
There is an IA for additional substantial question of law.
That's
13448.
sorry
13448 of 2023.
Two IAs filed last year.
Your addition, the earlier IA that was filed for additional substantial question of law, we are liberty may be going to withdraw that.
which one? IE number
1251
IE number 12518
filed on 9th of
of 2025. The Learned Counsel for the applicant seeks permission to withdraw this interlocutory application, and I submitted that another interlocutory application has been filed proposing additional substantial permission. This IA is dismissed as withdrawn. अगले में क्या? लैंडलॉर्ड टेनेंट की कहानी क्या आपको बनाना है?
we are claiming to be the landlord.
So, read it. You have to substantiate the substantial question of law. ऐसे थोड़ी होगा।
I will just clear out.
हाँ ऐसे यूज़र दिए हैं इसको अगर
आपको रिस्पॉन्स करना है।
हाँ थोड़ा सा मतलब I will be ready that it will be better for them also
बड़ी खुशी की बात।
so that we can assist them.
आप फाइल करिए और उसको मौज है। आप पोजीशन में है ना?
हाँ
आराम से दें। आइए नंबर 1 of 2025. Counsel for the parties are present. Interlocutory application has been filed proposing additional substantial question of law. Counsel for the respondent prays for some time to go through the same and file a response if any. Post on 7th October.
Item 4, second appeal 4 of 2004.
But in this case, appellant number 2 have expired, and we have given the improvements report.
You have filed it?
No, Lord.
You have filed, you have given a journals?
Yes, I have given that to him.
When did you die?
Lord, appellant number 2 have died.
When?
Yes. Lord, in the year
5th
2000,
August को ही आपका बताइए in the year
2017, 15/3/2017 he have expired.
you have received any instructions?
Yes, sir, we have received instruction, Lord.
SA number 4 of 2004. Council for the Appeal submits that Appeal number 2 has expired way back in the year 2017. He has received instructions to take appropriate steps. Who is for the respondent?
Lord, respondent Mr. Virendra, his name is appearing. Lord. I have sent him a WhatsApp also.
How much time do you need? Already a bit हो चुका है, अब आपको इंस्ट्रक्शन आ गया है, देर मत
हाँ,
बताइए कितना टाइम चाहिए?
एक वीक आफ्टर वेकेशन तो बंद हो जाएगा.
At the request of the Council for the Appellant, the matter is directed to be posted on 13th October? On
14th of
On 14th of October. Apparently, the proceeding against the respondent number 2, appellant number 2, in connection with appellant number 2 has already abated. Abatement तो हो ही गया ना? You have to pay for it.
Item 5, second appeal, 17 of 2004.
Yes, appellant. Pass over 2004 के केस में क्या pass over चाहिए? Open your file, please. This appeal shall be heard ex parte on the next date of hearing. भाई अब बहस करिए, ऐसे कैसे होगा? शुरू करिए ना, your senior will come down with you. Start, open the file. घर पे नहीं पढ़े? अब पढ़िए. शुरू करिए पढ़ना. कौन सा substantial question of law? कई बार इसमें फाइन इम्पोज करके एडजर्न हो चुका है. ठीक है, बुलाइए. एक केस के बाद कॉल करिए. घर से पढ़ के आया करिए फाइल, बिना पढ़े नहीं आने का इसको, नहीं तो पूरा ऊपर से नीचे तक पूरा जजमेंट पढ़वाएंगे.
From the supplementary list, under heading for admission, item 3, contempt civil 669 of 2023.
Yes.
They have taken last time, they have tried an idea which was a long-term edition, by which they have said that they are preparing SNP against because the LPL was dismissed.
Have they filed SLP?
Yes, I'm not aware of that.
You are not aware as to whether they have filed SLP or not.
Yes, order has not been.
मिस्टर विपिन चंद्रा का नाम फ्लैश करो,
जी।
इसको पास ओवर कर।
Under heading for final disposal, item 6, second appeal 87 of 2009.
This judgment of reversal,
You have circulated advance notice,
but
बिना कॉस्ट पे नहीं हुआ। आपको पेपर बुक भी मिल गया है, सब कुछ मिल गया, ऑफिस से पेपर बुक आपको मिल गया। अब आपको टाइम चाहिए पेपर बुक पढ़ने के लिए।
not paper book का
ऐसा होता नहीं है, लेकिन फिर भी आपको दे दिया गया। मे बी एट योर ओन कॉस्ट, व्हाटएवर।
no not
शॉर्ट नोट्स भी आपको बनाने के लिए था, वो भी आपने किए हैं। पहले भी दो बार एडजमेंट हो चुका है, एक बार 1000 रुपये कॉस्ट लगा, एक बार 2000 रुपये कॉस्ट लगा, इस बार 20,000।
अब जो नोट्स तो ये आपको अपने पास से बताओ क्या
सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है ना,
हाँ सब्सटेंशियल क्वेश्चन
बताइए कहाँ है?
but this is order number 5 10/10/2011 whether the learned lower appellate court has committed serious error in reversing the finding of the learned trial court on the issue of adverse possession without considering the effect of exhibit 2 coupled with evidence of DW2 4 and 6 which were taken into consideration by the learned trial court for recording his finding.
बस ठीक है ना, पढ़िए, खोलिए पढ़िए। ये तो 20,000 रुपये कॉस्ट होता है। ओपन द ब्रीफ एंड स्टार्ट। एडवर्स पोजेशन का प्ली था किसका? प्लेंटिफ का कि डिफेंडेंट? यू आर फॉर द
I am for the plaintiff.
यू आर फॉर द नेक्स्ट। देखिए आपको तीन चीज देखना है, एग्जिबिट 2, एग्जिबिट
Exhibit 2 and 3W.
let us see the trial court judgment because trial court judgment was in your favor.
Yes.
Correct? Let us see what is the discussion.
The plaintiff suit is for declaration of his title. Entry is made in RS 020.
थोड़ा जी को मिलेगा आपसे लंच टाइम में।
जी।
पढ़िए पढ़िए, सोचिए मत। You come to page number 9. Page number 9 of the trial court judgment.
Page 9.
Top से देखिए. Now it is to be seen whether the plaintiff and their ancestors are in continuous possession of this land for more than 30 years. Government property है. You are from the state.
इसमें नहीं.
30 years का कहानी क्यों आया?
अच्छा डिप्टी कमिश्नर भी पार्टी है क्योंकि ये पार्टी प्लॉट है सीएनटी एक्ट से बिलोंग करते हैं इसीलिए, लेकिन गवर्नमेंट प्रॉपर्टी
नहीं। तो फॉर्मा नेसेसरी पार्टी होता है फिर भी प्रोफॉर्मा यहाँ पे तो पढ़ लो। ओके रीड इट प्लीज।
yes.
Now it is to be seen.
Now it is to be seen whether the plaintiff and their ancestors are in continuous possession over the suit land for more than statutory period, that is 30 years, and whether the possession of the plaintiff was open and hostile. In this connection, the plaintiff have adduced oral evidence and have also put their reliance on the documentary evidence. Now let us first discuss the oral evidence. PW2, one of the plaintiff in this case, have stated in his deposition that the suit land, throughout remained in the possession of the plaintiff and his ancestors. PW3, one of the independent witnesses at paragraph 2 of his deposition, have also stated that the suit land is in possession of the plaintiff and prior to them their ancestors were in possession. PW5 in his deposition has stated that he plowed the suit land on behalf of the plaintiff. In his cross-examination, the witness have also stated that he has never seen Musmat Parbatia plowing the suit land. PW4 and 6, though admitted the possession of the plaintiff, but have stated that for some period Musmat Parbatia had plowed the suit land. PW7 have also stated regarding the possession of the plaintiff and the cross-examination, he has stated Parbatia never had plowed the field during her lifetime. PW8, who belonged to the same foot to which the defendant belonged, have stated in his deposition that previously Jagat Narayan was the owner in possession of the suit land, and 32 years back he has executed a deed in favor of Rama. PW9 and 10, who are the plaintiff in the case, have also supported their own case. So far as deposition of defendants are concerned, DW1 is one of the defendants in the case. He has stated that during the lifetime of Subhash Parbatia, he did not claim the suit property. DW2 is the wife of DW1. In her deposition, this witness has stated that after death of Musmat Parbatia, she is cultivating the suit land. However, in cross-examination, this witness has stated that she has not seen any document pertaining to the suit land and she has no idea about the right title of the suit land. The witness has also expressed her inability in describing the boundary of the suit land. As at para 18, the witness has stated that the plaintiffs are plowing the suit land forcibly every year. As such, it appears that the witness of the defendant have also supported the possession of the plaintiff over the suit land. DW4 in its deposition at para 5 has stated that presently the plaintiff are in possession of the suit land. At para 7, this witness has stated that plaintiff used to cultivate the suit land even during the lifetime of Musmat Parbatia. Again in para 14, this witness has stated that plaintiff are in possession of the suit land since long. Para 15, this witness has stated that Musmat Parbatia and Punjab never objected possession of the plaintiff. DW5 in his deposition has supported the possession of defendant, has stated that once the defendant had plowed the field with the help of tractor. However, in cross examination, the witness has failed to narrate about the boundary of the suit land. He has stated that he has not seen any document relating to the suit land and cannot say how many plots of the suit land comprise of. The witness have also stated that though he belonged to the different village of defendant, Sadev Bhagat is the grandfather. Lastly, DW6 has stated in his deposition that Sadev Bhagat is cultivating the suit land since last 7 years. Again in para 17, this witness has stated that after death of Musmat Parbatia, Sadev Bhagat is claiming over the same. From the deposition of the plaintiff as well as defendant, it becomes clear that plaintiff are in possession of the suit land since long. Now it is to be seen whether the plaintiff are in possession of the suit land, whether the plaintiffs are in possession of the suit land for more than statutory period to claim adverse possession. Now let the documentary evidence used by the parties be discussed. Exhibit 5 is certified copy of survey Khatiyar, new Khata number so and so, rising area. It appears that the same has been prepared and published as Pakat Huriyajim Makoi and Musmat Parbatia has been shown in the tenure holders. Further, in remarks column, illegal possession of Rama Urao and Lachu Urao in equal shares since 1975 have been shown. From this, the possession of the ancestor of the plaintiff, at least from 1975, is proved. Apart from this, though the deed of relinquishment, Exhibit 2, did not create any title in favor of plaintiff, the same being his by Section 46 CNT Act, but at least this goes to show that the ancestor of the plaintiff is in continuous possession over the suit land prior to 1961. Exhibit 2 was executed. The learned counsel for the defendant submitted that possession of the plaintiff was not continuous, as the last surviving member, Musmat Parbatia, had filed SAR case for restoration of the land. However, it has been submitted by the learned counsel for the plaintiff that SAR case filed by Musmat Parbatia was disallowed, and against that no revision or appeal whatsoever has ever been preferred by her. and as such the order of SAR case attained finality. Hence it could not be said that by filing SAR case Mr. Parbatia had interrupted the continuous possession of the plaintiff. Learned counsel for the defendant further submits that in the year 1978, defendant Sadev Bhagat filed mutation case number 128 to 79 for getting the suit land mutated, and while order dated 9/3/79 the same was allowed. Challenging the said order, referred appeal in the court of LRDC Lohardaga, in which order passed in mutation case was reversed. In the second appeal filed by Sadev Bhagat, the original defendant before additional collector, the LRDC order was reversed. Against that revision being case referred by the plaintiff in the court of Commissioner South Chotanagpur, which was disallowed on this matter. The learned counsel for the plaintiff on the other hand said that the order of commissioner was not correct and hence no reliance could be put on the same. On this point, I am of the opinion that whether the order passed by commissioner was right or wrong, that is out of purview of this court. However, the certified copies of Satyan exhibited in the case, it appears that the nature of the suit property Bhujari Mehul, as per section 2Q of the Bihar Land Reform Act, the tenure does not include Bhujari tenure prepared and confirmed under CNT Act. Chapter 2 of the Bihar Land Reform Act 1950 deals with vesting in the state or tenure in the state and its consequence. Section 4 of the said chapter more fully describes the same. Clause B of section 4 reads as follows. As Bhujari tenure is not tenure, as per section 2Q, the same did not vest in state. As such, Bhujari tenure continued to remain rent-free land and only cess is payable of the said land. As Bhujari tenure did not vest in the state, the question of mutation in favor of anybody does not arise. Over and above, mutation itself does not create any title or extinguishes the same in favor of anybody. Hence, even if the land was mutated in favor of defendant, it would not be said the same created any title in favor of defendant. Moreover, filing of the case of mutation in itself does not amount to disturbance in continuous peaceful possession. From these discussions, it becomes clear that possession of the plaintiff over and their ancestor over the suit properties is for a period of more than 30 years and the same was peaceful. Now, second question for consideration is whether the possession is open and hostile to possession of the original owner. Exhibit 2 is the deed of relinquishment. It appears that the son of original owner had never objected the possession of the plaintiff and he relinquished his interest by executing Exhibit 2 acknowledged the same. During the lifetime, the original owner or his son never objected to the possession of the plaintiff and plaintiff's ancestor. Though Mr. Parbatia had filed a SAR case for restoration of the suit land, but the same was disallowed, and against that no revision or appeal whatsoever has been preferred by her, and as such the order passed by SAR has attained finality. Hence, from the time of the recorded tenant Sadev Mahto till the death of the last surviving member Usman Parbatia, the plaintiff is in peaceful possession of the suit land so far as the present defendant are concerned. They are nearest male agnates of the original owner. As per the Orav customary law, only on the death of the last surviving male member of the family, the suit land will devolve upon them. As such, so long as Usman Parbatia was alive, the defendant has no role to play in the suit. From the discussions made above, it becomes clear that the possession of the plaintiff and their ancestors over the suit properties were continuous and for a period of more than statutory period, and it was open and hostile to the possession of the original owner, and the original owner never objected the same. As such, it becomes clear that the plaintiff has perfected title by over his possession.
Exhibit 2 is a relinquishment deed.
It is a relinquishment and exhibit. Sorry.
Dated.
But it says it is continuous possession of the suit land prior to 1961 when Exhibit 2 was executed. So it should be not 1961.
This is violation of articles.
Section 46. Yes.
What is the impact?
But let us take an example. That if a suit is also filed and there is a compromise between the parties which belongs to the members of, which is governed by CNT Act, then it is in violation of section 46. Then also the possession can be counted from.
Be acknowledged.
No, possession can be acknowledged.
Nothing, because such a decree, such a document is null and void. And if it is null and void, we have to treat it as if it never existed.
Therefore, let us see a situation. Because here, it is only with respect to possession.
Yes.
It is only with respect to possession.
Even with respect to possession.
Yes.
If there is a relinquishment in connection with possession,
yes,
right? Then also this document cannot be relied upon.
These documents can be relied
So you have
only
to show a judgment
Yes.
that this document still can be relied upon to show
with
the
respect to
possession.
possession. Exactly.
So you have to show me a judgment on this
Yes.
because I am of the view that since it is null and void, anything mentioned therein cannot be taken care of, cannot be considered
Yes.
to come to any finding. Possession and title are two very important ingredients in connection with immovable property. Right? Title certainly cannot pass.
Yes.
Even possession cannot be acknowledged by virtue of this document.
But I will show that.
This is one thing. What about evidences? What about the learned first appellate court?
Yes.
You see, the evidences have been considered by the learned trial court.
That.
First appellate court.
First appellate court.
Why was 30 years to be taken into consideration instead of 12 years? Because it is
two
CNT
private
land.
parties.
It is CNT land after all.
But CNT land, but it is only with respect to once a point of adverse possession comes into play. Then it is with respect
This 12
to
years
it is 12
is to
years.
be read as 30 years. I
But
think.
so far as restoration is concerned, in that note 71A,
That regulation, if there is an
69.
amendment,
but that
there is an amendment
there
in
is
the
an amendment
CNT Act
in the
with
CNT
regard to
Act.
limitation.
Yes, correct.
Let us see that. Dahi zara, CNT Act. What is that amendment?
Lots of in this case, lots of Mr. Ashok Kumar Pandey, lots of arguments.
So हम adjourn नहीं
Praying
करेंगे.
tomorrow, lots of.
आपके काउंसिल ने टाइम मांगा ही नहीं. आप बताइए, which is that amendment? उसको चेंबर में डालिए.
So, Lordship,
कोई बात नहीं. कितना दिन हुआ आपको प्रैक्टिस करते?
less than 1 month.
Less than 1 month.
Please now, he's out of town.
Who?
The Agri Council, Ashok Kumar Pandey.
कल करना चाहते हैं?
हाँ, करा देंगे.
आप करेंगे ना? आप करेंगे कि नहीं करेंगे? आप करेंगे तो टाइम दें.
जी, मैं कोशिश करूँगा.
जजमेंट दोनों पढ़ के रखने का. कहाँ से पढ़ें? कहाँ से पढ़ें? पढ़ाई कहाँ से की है? रांची से ना. तो छोटनागपुर टेनेंसी एक्ट तो पढ़ाई होता है ना यहाँ, है ना? तो यू हैव अ स्पेशल नॉलेज इन छोटनागपुर टेनेंसी एक्ट. करेक्ट? तो हिंदी में भी बेंच कर सकते हैं. ऐसा कोई अंग्रेजी का कुछ ऐसा नहीं है, लेकिन पढ़ के आए. अब बताइए विच इज दैट अमेंडमेंट?
Can I have the book? Mark.
आपके पास इनके लिए बुक नहीं है? होगा.
Bihar scheduled area regulation.
1969.
बताइए. कहाँ?
But this is in appendix 9.
लिमिटेशन आर्टिकल्स.
Article 60.
इसमें 30 है ना?
30.
आप हमको ये मत बताइए कि आपको पता नहीं.
नहीं notes. हम तो एडवर्स
देखिए, मैंने सीएनटी का केस ड्यूरिंग माय प्रैक्टिस नहीं किया था, लेकिन थोड़ा थोड़ा पढ़ रहे हैं और धीरे धीरे समझ में आ रहा है. ठीक है? अब 30 इयर्स आपको प्रूव करना है, 12 साल नहीं प्रूव करना. 30 इयर्स 1961 से तो हम मानेंगे नहीं.
नोट अगर हम जजमेंट दिखा देंगे तब.
हाँ हाँ बिल्कुल मानेंगे. आप
वही बोल
जजमेंट
रहा
आप देंगे
हूं.
तो
Your Lordship will not close my doors.
I will not close anybody's door. चलिए appellate court पढ़िए. Para 7. You see, so far as the oral evidence is concerned, you are claiming adverse possession from which date? अच्छा कोई फाउंडेशनल डेट तो आपने दिया नहीं.
फाउंडेशन.
तो 30 इयर्स आपका कब खत्म हुआ?
So if we count notes so far as question of law is concerned, Exhibit 2, 1961.
1961 से आप claim कर रहे हैं.
1961 is the.
Is there any oral evidence of these three or witnesses
Yes.
जिसके बारे में है, with who say defendant number 2, 4 and 6 that you were in possession since 1961?
Oh. Notes what the trial court have recorded. There is no date as such.
There is no date mentioned.
There is no date
So
mentioned.
the only documentary evidence to show that you were in possession, rather the only evidence to show that you were in possession since 1961 is
Is Exhibit 2.
Nothing
Because
else.
Exhibit 5 notes is
So
75.
everything will, and there is a presumption in connection with recording of Khatyan, recording Khatyan under the CMT Act.
Yes. So far as Khatyan is concerned, in the remarks column it says from 75. So 75 notes, I will not
75
qualify
से
30 years.
नहीं,
I will not qualify 30
you will
years.
not qualify.
So that is not.
So you have to take recourse to exhibit 2.
Exhibit 2 only.
उसके बिना कोई और evidence नहीं.
Exhibit 2 only.
और अगर exhibit 2 null and void है, whether possession can be taken into consideration by
Yes.
referring to exhibit 2, everything will boil down to that.
Yes.
So far as the other witnesses are concerned, उनकी कोई जरूरत नहीं है क्योंकि 75 से already recorded है. They have not given any specific statement from 1961. Concluded.
So but कल अगर हम लोग एक
अरे भाई 1 महीना का बच्चा है.
नहीं हम
इसको जिताने का मन है. आपको नहीं समझ आ रहा है.
इसको सिखाइए.
जिताने का मन.
जिताने का मतलब
सिखाने का नहीं, जिताने का मन.
बट जीतने हारने से सीखता नहीं, बट सीखता है बहस करने.
जीतने
तो वो बहस करवा दीजिए, जिताने का करवाने का. Well, because my initial days was I lost most of my cases.
Most of
my cases. The first case which I argued was before Justice Ajit Kumar Sinha.
तो हार के आगे जीत है. सुन लिया. कल आप चले आइए. ऐसा मत बोल दीजिएगा कि हम ऐसा बोले हैं कि आपको जिताएंगे. आपको हरा भी सकते हैं. ठीक है. अब ये कौन सा जज है? सीतू साहू लेके आएंगे और क्या लेके आएंगे?
नहीं, हम अपने ही कोर्ट का लाएंगे, which will show क्या है, क्योंकि what I have to show basically by judgment कि even if a document is contrary to section 46, then also possession on that document.
Date क्या है? What is the date of exhibit? नहीं record. और exhibit 2 देखो.
What is 61? 28/11/61. Suit 99.
Heard the counsel appealing on behalf of the parties. This appeal has been admitted for final hearing by the order dated 10/10/2011 by framing the following suggestion. The learned counsel for the appellant has submitted that the judgment filed by the learned first appellate court is perverse on account of non-consideration of the evidence of DW 2, 4 and 6 and also non-consideration of the effect of executive. He has referred to internal page 9 of the trial court judgment and has submitted that the learned trial court had specifically framed an issue as to whether has specifically considered as to whether the plaintiffs and their ancestors are in continuous possession over the suit property for more than statutory period, that is, for more than 30 years, and whether the possession of the plaintiff was open and hostile. The Learned Counsel has referred to regulation.
But this is the Bihar Scheduled Area Regulation 1969.
The Bihar Scheduled Area Regulation 1969, Appendix 1, sir.
Appendix 9.
Appendix 9.
Yes.
To submit that, the point of 30 years for adverse possession arises due to the amendment with regard to the period of limitation to deem adverse possession. The provision is quoted as ये running page 354 में है और इसको यहाँ से कोट करना है नंबर 2 को. He submits that all the materials were considered and the exhibit 2 clearly revealed that the plaintiff was in continuous possession of the suit property since 1961. The Learned Counsel submits that the Learned Trial Court has specifically recorded that though the deed of relinquishment exhibit 2, which is dated 28/11/61, does not create any title in favor of the plaintiff being hit by the provisions of section 46 of the Jharkhand Tenancy Act, but it goes to show that the ancestor of the plaintiffs were in continuous possession over the property prior to 1961 when exhibit 2 was executed. He submits that though the title did not pass by virtue of exhibit 2 being hit by provision of section 46 of the Jharkhand Tenancy Act, but the document was sufficient to prove the possession prior to 1961. The period of 30 years expired in the year 1991 and the suit was filed?
The suit was filed in 99.
In the year 1999. The Learned Counsel has further submitted that so far as other ingredient of adverse possession, that is whether the possession was open and hostile was also considered by the Learned Trial Court, and finding was returned in favor of the applicant. And while recording the finding, Exhibit 2 has been taken into consideration, which is a deed of relinquishment, and the Learned Court recorded that it appeared that the son of the original owner had never objected the possession of the plaintiff and he had relinquished his interest by executing a deed, Exhibit 2, to acknowledge the same. He has also submitted that the Learned Trial Court has taken into consideration that filing of SAR case for restoration of land, which was ultimately disallowed, has also been taken into consideration. The Learned Counsel has referred to paragraph 7 of the Learned First Appellate Court judgment. And has submitted that the exhibit 2 has been considered in isolation, and the oral evidence of BW any oral evidence of BW 2, 4 and 6 have not been taken into consideration. However, during the course of arguments and upon going through the improved judgments, there does not appear that he has not been able to show any oral evidence of these witnesses substantiating the case that the plaintiff was in possession of the property prior to 1961. The learned counsel submits that the exhibit 2 has not been properly appreciated by the learned first appellate court, and the substantial question of law be answered in favor of the appellant. He has submitted that the matter be posted tomorrow so that he may place a few judgments to show that even if the transfer is in violation of section 36, the possession can be used to show possession. आपका नाम बताइए?
अनुकूल गौरव.
Advocate Mr. Anupul Gaurav has opposed the prayer, and he has submitted that he shall advance his arguments tomorrow first page 10:30.
जी. Past work is item 5, second appeal 17 of 2.4.
Read the substantial question of law, please.
Pardon me, Lord.
The substantial question of law पहले पढ़िए.
My Lord. Whether instead of
Yes.
whether instead of weighing the oral evidences, the courts below should have insisted for further documentary evidence for holding that there was no partition between the parties.
Please explain this substantial question. Please explain this substantial question.
Sorry.
Can anybody insist on further documentary evidence? Can a court insist on further documentary evidence if the parties are not?
True, madam. No documents have been brought, my lord, to show that it was a joint property. Now here, my lord, I'm just placing for your lordship's consideration. The suit is for 1/5 share.
Yeah, the plate written statement. So this substantial question of law, does it arise?
Not very substantial. The substantial questions of law, my lord, which I feel, my lord, for your lordship's consideration
Sir,
are
ऐसे
this
नहीं बन
place.
सकता substantial question. Not like this.
Because liberty was given also. So if your lordship so feels, my lord,
No, we do not. ऐसे orally इस तरह से नहीं बनता है. For substantial question.
नहीं नहीं पूरा question of
reason
law.
order is to be. Where is the other side?
The side to the notice.
The suit was decreed, dismissed.
Suit was decreed by both the courts. We are defendants, my lord. We are the brothers of the recorded tenant, and my lord, the daughter had filed a suit, partition suit, in 1993, my lord, claiming 1/5 share. Now,
And that was granted to her.
that was granted. Now, my lord, the point which I want to raise, for a substantial question of law which I want to raise, my lord, is this. Number one, my lord, that Order 2, Rule 2 CPC, that bars, my lord, a suit for partial partition. Now, in the whole of the plaint, the properties in Bengal have not been whispered at all. And when, and in written statement, we said कि वहाँ भी जो property है, तो उसका हम लोगों ने जिक्र किया हम लोग. And in course of evidence, वो admit की है the plaintiff PW1 कि वहाँ भी properties है जो उन लोगों का कहना है कि joint है. Now, so partial partition of the lands of Dumka is in violation of Order 2 Rule 2 CPC.
सर इस तरह से बिना आईए फाइल किए कुछ भी इस तरह से एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बना सकते.
एक आइए बना देते हैं मैडम.
ये 2004 में अभी तक क्या करते हैं? 2004 से
एक आइए, if your lordship will permit me, my lord, एक आइए हम बना के देते हैं. और दूसरा एक क्वेश्चन बनेगा my lord.
She has relinquished her claim. So the additional, a person may say that I am not interested in that property. I don't claim at all.
No, not. It was our case, my lord, of the brothers, defendants, that they relinquished the claim of Dumka properties, and they were given the Bengal properties because their sasural were in Bengal. So it is our case of relinquishment by them relating to the Dumka properties, which is the suit property, my lord. So, and that our lord, contention of relinquishment by the plaintiff, that has been rejected by the court. कि कोई डॉक्यूमेंट वगैरह या फैमिली सेटलमेंट का ऐसा कुछ प्रोड्यूस नहीं। So the Bengal properties were completely, my lord, suppressed in the plaint, not whispered. And in the written statement, my lord, we
The learned counsel for the part appellant, nobody appears for the respondent, counsel for the appellant is present. The learned counsel submits that liberty was given by the order dated 18/5/2006 by admitting the case. Today's other substantial question of law. It submits that there are other substantial questions of law involved in this case. And raised for them. Raised for time to file an appropriate petition. आपको तो पता ही है क्या सबस्टेंशियल क्वेश्चन ऑफ लॉ, आपको पता है ना एडिशनल क्या है। एक सेकेंड, तो आप उसको ऐसा स्लिप उसमें फाइल करा दीजिए आप, राइट, सर्व द कॉपी ऑन टू द अदर साइड।
एक आइए बना के दिया,
आइए पार्टी नहीं भी आए तो भी बना सकते हैं, बिकॉज़ इट इज
पार्टी नहीं भी आए
तो भी आप बना सकते हैं।
और उनके हो सकता है लॉयर वगैरह उन्होंने बात कर एक कॉपी सर्व कर
कॉपी सर्व करके द नीडफुल बी डन बाय फ्राइडे, नीडफुल बी डन बाय फ्राइडे। आपको पार्टी का जरूरत नहीं, इसके लिए आप ऑलरेडी बना चुके हैं, कर दीजिए इसको, हो जाएगा।
उनका जो आदेश होगा वो हम लोग करेंगे, लेकिन पूजा वूजा के बाद उसको रखवा दिया जाता है।
ठीक है, नीडफुल
नवंबर वगैरह
जस्ट अ मोमेंट,
छठ के बाद
कौन सा छठ?
पार्टी को भी बुला लेंगे या जैसा भी माय लॉर्ड्स कोई भी डेट फिक्स कर
Needful be done latest by 6th of October, failing which no further opportunity will be granted.
मिलो
Post on 7th.
मिलो
We need to rise.